Guilherme is the person who is here with us. He's the one who's gonna send you the questions.
Sorry, I'm sorry to be 3 minutes late, but we are going about to start. We just need 1 minute for YouTube, because if we start talking now, we are going to broadcast on YouTube. So from now, I'm going to shut down my camera and microphone, and we are going to have 1 minute, and 1 minute from now, we are going live, okay? I wish you all a great event, and we are going to be here, although we are with cameras closed and mics closed, we are going to be here, and if you need, we
Já ficou na sua tela. Pode. Então, você me dá que eu faço um joinha aqui para ele.
Good morning to our Brazilian audience and good afternoon to our German audience. Welcome to the second webinar STF Münster University, Constitutional Courts and Countermajoritarian Protection, an international event hosted by the Brazilian Federal Supreme Court and the University of Münster, Germany. Last year, the Brazilian Federal Supreme Court signed a cooperation agreement with the University of Münster, and this series of webinars about globally relevant themes is one of our joint products. In the second edition, the event aims to highlight the role of constitutional courts and the counter-majoritarian difficulty in the protection of fundamental rights. Initially, we will open our event with a message from the keynote speaker, Justice Luiz Roberto Barroso of the Brazilian Federal Supreme Court.
Good morning. It's a pleasure and an honor to be here and to share with everyone some ideas and some thoughts on this subject, constitutional courts and counter-majoritarian protection. I want to talk a little bit about constitutional democracy in the first part, then a little bit about the roles, missions and the roles of the courts. And in the third part, we're going to talk a little bit about the role the courts have been playing in some parts of the world to protect democracy against extremist authoritarian populism. So I start with our first chapter, our basic and conceptual chapter relating to constitutional democracy, which is the winning ideology of the 20th century, having defeated all the alternatives that presented themselves: communism, fascism, Nazism, military regimes, and religious fundamentalisms. Constitutional democracy is the product of two ideas that came together. They have different origins, they ran different trajectories, but they merged at some point in the 20th century. Constitutionalism and democracy. Constitutionalism is the heir to the liberal revolutions, English, American, and French, and means substantially, essentially, limited power, rule of law, and protection of fundamental rights. Democracy, on its hand, is an idea that was only consolidated during the 20th century when universal suffrage prevailed. and all the restrictions to popular participation were abolished. Restrictions relating to wealth, to religion, to race, and to gender. Democracy means popular sovereignty, rule of the majority. That's the essential idea. Furthermore, in most countries that adopt this model of constitutional democracy, they also include in their institutional arrangement a Supreme Court or a constitutional court that has as one of its main roles to arbitrate the tensions that sometimes may arise between democracy and constitutionalism, between the will of the majority and the protection of democracy and the protection of fundamental rights. So in modern democracies, the three main missions, I could say, of a Supreme Court or of a constitutional court is to ensure the government of the majority, to preserve democracy and the rules of the democratic game, and to protect fundamental rights. These are the three main missions of a Supreme Court or of a constitutional court. In its attempt to accomplish this mission, the courts have played three main roles, I would say. The first one is the countermajoritarian role, and that's a traditional view of constitutional theory. But there are two other roles that I would like to highlight here, which I also consider very important, which is a representative role and the enlightened role. So in my view, constitutional courts and Supreme Courts play three different roles: countermajoritarian, representative, and enlightened. The countermajoritarian role is traditionally acknowledged, as I said, by constitutional theory. And this expression, due to Alexander Bickel, basically identify the fact that Supreme Courts or constitutional courts have the power to declare an act of Congress or an act of the executive unconstitutional. And the name countermajoritarian difficulty is due to the fact that judges who are public officials that are not elected can superimpose their will, their interpretation of the Constitution over the interpretation that is carried out by the two other branches whose members are elected by popular vote. But constitutional theory has settled the legitimacy of this power, although there are some theoretical resistance by important authors like Jeremy Waldron or my good friend Mark Tushnet. But the prevailing view is that it's a legitimate role played by Supreme Courts and constitutional courts, at least since Marbury versus Madison, and after Second World War II, starting with the German fundamental law and the German Federal Constitutional Court, most democracies, over 80%, almost 90% of democracies, do follow this American model of constitutionalism, which is based on constitutional supremacy, granting the power to a judicial body or a judicial-like body to be the final arbiter of the meaning of the Constitution, with the power to invalidate acts from the other branches. This is basically the idea of the countermajoritarian role of a Supreme Court or of a constitutional court. And it's a very important role because it protects democracy and fundamental rights from the tyranny of majority. But one thing I would like to highlight here that I think is very important, the fact that a Supreme Court or a constitutional court has the power to act in a counter-majoritarian way does not mean that it ordinarily acts this way. In most cases, the constitutional courts decide aligned with the majorities, aligned with the common sense. And this gives these courts the political capital to invalidate acts when that's really important. So the counter-majoritarian powers should be exercised with great caution and great parsimony. Besides this counter-majoritarian role, courts have a second role, many times overlooked, which I call representative role, meaning that there are social demands by society and entrenched in the Constitution that are not satisfied by the majoritarian branches. And many times, on behalf of the Constitution, Supreme Courts may have to decide to enforce constitutional provisions, even in the omission, in the inertia of the other branches. One good example here in Brazil was the case of nepotism, the prohibition of appointment of relatives to public positions, which was a social demand, an important social demand that was not satisfied by proper legislation. So the Supreme Court decided that it was against the Constitution to appoint relatives to positions that filled by free appointment. An example in the American tradition, I would highlight Griswold versus Connecticut, the case involving contraceptive measures, in which the Supreme Court declared unconstitutional a statute that prohibited its use in a world, we were in the 60s, where of course the majority would accept this use of contraceptive measures. And the important decision in Lawrence versus Texas, when also satisfying a social demand, the court decided that it was unconstitutional to criminalize gay relationships, basically. And the third role is the enlightened role. That's a dangerous role that must be exercised with great caution, but sometimes it's very important when history needs to be pushed against common sense, against the views of the majority. But then we need a humanitarian reason to push history in very few moments, but they are very important. An important example in the United States was the decision in Brown versus Board of Education against racial segregation in public schools. In Brazil, it was the decision that validated gay rights and same-sex unions. In South Africa, the decision that banned the death penalty that had as its main victims the Black population. And maybe I would include in this list the important decision by the German Constitutional Court in the Luth case. So there are moments in history, very few, but very important, in which the court has to push history in the name on behalf of a humanitarian reason, usually to protect minorities. So these are the main roles of a constitutional court. And now I want to talk a little bit about the role courts have been playing, successfully or not, in their role of protecting democracy in the contemporary world. The world is going through a moment in the past few years, maybe a little over a decade. It's going through a moment that has been baptized by different authors as constitutional recession or constitutional retrogression, or abusive constitutionalism, or autocratic legalism, or competitive authoritarianism, identified by the fact that leaders elected by popular vote drive their countries progressively towards authoritarianism. The examples are multiple: Hungary, Poland, Turkey, Russia, Georgia, the Philippines, Venezuela, Nicaragua, more recently, El Salvador. This feature that I just mentioned is what distinguishes the erosion of democracy these days. The erosion of democracy is not the product of a coup d'etat led by generals and their soldiers, but led by prime ministers or presidents that are elected by popular vote. And then brick by brick, they deconstruct many of the pillars of democratic constitutionalism, concentrating power in the executive, persecuting members of the opposition, demonizing the press and civil society entities, changing the rules of the game with the abusive use of power by the majorities, or attacking Supreme Courts and other institutions. That has been the pattern. In fact, there are three different phenomena going on: populism, extremism, and authoritarianism. But when they come together, they become very dangerous to democracy, because they involve a division of society between we, the pure, decent, conservative people, and them, the corrupt, cosmopolitan, liberal elites. So it's an anti-pluralistic view, generally led by personalist and charismatic leaders that are elected, promising to be different from everything that's out there, promising to be anti-establishment, and quite often clashing with the institutions, because there is an intrinsic problem with populism, which are, actually there are two, which are, first, people is not a homogeneous category. People is a plural concept. So no one can claim to be the only legitimate representative of the people. And also the elites is not an homogeneous concept either. You have, of course, extractivist elites that you want to get rid of, but you need, like every country needs, an intellectual elite, and elite in the public service, an elite in the business area. So this is a totally flawed ideology. I won't have the time to explore a little bit more the concept of populism and extremism and authoritarianism, but I will just say that the strategies that they usually employ are, first, a direct communication with their supporters, with the masses, more recently using social media. In the second place, they bypass or they co-opt the intermediate institutions that mediate the relationship between the people and the institutions. So they usually bypass or co-opt Congress and social civil society and the press. And thirdly, and more directly related to our subject here, populists tend to clash with Supreme Courts and with constitutional courts, and tend to attack them, because the main role of a constitutional court, of a Supreme Court, is to interpret the Constitution, and the Constitution is a document that limits political power. So the role of a Supreme Court, of a constitutional court, quite often is to say no to the elected political powers. And as one can easily understand, there's always a natural tension between the political powers and the Supreme Court. In democracies, these tensions are absorbed in a civilized institutional way, but in authoritarian populisms, they usually involve some sort of clash of dispute between the two. There are some cases in which Supreme Courts or constitutional courts successful faced authoritarian populisms. And there are unfortunately cases in which these courts were defeated, were totally captured and packed. And before finishing our presentation, I will mention a few cases. I'll start with the cases with the success stories. One of them so far has been Brazil, where the Supreme Court, I would say quite successfully, has acted as an important barrier against some excesses. And I should say that in most parts of the world, populist leaders try to relate with constitutional courts or with Supreme Courts, trying to capture them by appointing submissive judges or try to strip the courts of many of their important powers. So in Brazil, there are very important decisions by the Supreme Court protecting freedom of speech, preserving civil society, preserving the participation of civil society in many councils that are important for public policies decisions. We have important decisions protecting indigenous peoples, protecting the environment, and the court leads in a criminal inquiry to face attacks against institutions, against democracy, and against the court itself. So far, the Supreme Court in Brazil has been able to act as an important barrier against the advance of authoritarian populism. I think I could say that in the United States, they also had a successful story. Donald Trump lost the elections and filed over 60 lawsuits. Two of them filed by his supporters reached the Supreme Court, but in none of these cases, he got what he wanted, which was voiding the elections in many states. So the judiciary, the courts generally, and the Supreme Court also acted as a barrier against authoritarian populism that wanted to disrespect the electoral vote. And in the US, as many know, until these days, although Trump lost by over 7 million votes, the popular vote, and over 70 votes in the Electoral College, he still claims that the elections were stolen, which is very regrettable because he makes many people believe in that. And that's just not true. That's just pure misinformation. Another success story was in Colombia some time ago in 2010, when the Constitutional Court decided that a constitutional amendment allowing for a third election of the president for a third term was inconsistent with the Constitution and precluded Álvaro Uribe to, start this third term in power. Those were successful stories, but there are less fortunate stories. They start with Argentina. I think the first precedent was with Juan Domingo Perón in 1946, when he was elected and he purged the Supreme Court from all of its judges there, just because he didn't like them. And in these days, probably the most emblematic case is that of Hungary. And what happened there, I won't have time to tell the whole story, but the court was progressively captured by the Fidesz party and by Viktor Orban with constitutional amendments and legislation that increase the number of judges from 15 to 11. That's a common strategy. Early retirements or increasing the number of judges so that you can appoint submissive judges. Indeed, he reduced the retirement age to open new vacancies, changed the criteria of appointing judges to make it more political, and removed powers of judicial review, especially regarding constitutional amendments. And the constitutional court in Hungary, once powerful, today is totally aligned with the government. A similar process occurred with Poland, where also constitutional amendments or legislation anticipated the retirement of judges, limited their jurisdiction, required a supermajority to invalidate statutes, and worst of all, gave the executive discretionary power to publish or not decisions of the court. In Latin America, the saddest story is the one involving Venezuela, where also the court was totally captured by Chavez and its followers, and then by Maduro. And in 2015, when the party in power lost majority in Congress, the Supreme Court acted to void most of the decisions by Congress and increasing the power of the president of Maduro, leading Venezuela to a dictatorship and truly to a humanitarian disaster. The same path was unfortunately followed by Nicaragua, where Daniel Ortega has been successfully re-elected with changes in the constitution admitted by a court that has been manipulated. So I won't have the time to go through all the cases of failure, cases in which Supreme Courts failed in resisting to authoritarian populism. But I think I was able to give a description of how I see the world today, the constitutional democracy as the winning ideology of the 20th century, the moment we are going through, which is the democratic recession and this rise of authoritarian populism, and the roles of the courts, countermajoritarian, representative, and enlightened, and more recently, the role courts have been trying to play to resist the advance of authoritarian extremist populism, mostly far right, but not necessarily. As a conclusion, we can say that Supreme Courts and constitutional courts can play an important role in protecting democracy, but they don't always win. And there is a proper balance there. If they don't play this role of resisting to autocracy, they're not playing their role at all. But in open conflicts with authoritarian powers, quite often courts lose. So my takeaway of everything that I said is that constitutional courts are very important, but they cannot do their job alone. They cannot do the job alone. They need civil society, they need free press, they need pluralism of political parties. And those factors are very important to resist extremist authoritarian populism. And there is one danger that must be avoided, which is the court becoming too political or partisan. Usually, populist authoritarian leaders will accuse the court of that, but that's not relevant. The court itself must be sure that it's basing its decision actually in constitutional principles and constitutional values. And hopefully they will be able to succeed. Thank you.
In this event, we will have two panels. In both, there will be close interaction between Brazilian and German thoughts. The first panelist will be Professor James Folks, and his debater will be Professor Patrícia Perrone. James Folks is a professor of foreign and international law at the University of Münster. He holds law degrees from the University of Witwatersrand, Johannesburg, and Yale Law School, where he completed his doctorate. He is the author of Building the Constitution, the Practice of Constitutional Interpretation in Post-Apartheid South Africa, and with Susan Rose Ackerman and Stephanie Edge of Due Process of Lawmaking, the United States, South Africa, Germany, and the European Union. He is a member of several editorial boards and scholarly collaborations in international and comparative public law. Patrícia Perrone is professor of the doctoral program at the University Center of Brasilia. She holds a master's and a PhD in law from the State University of Rio de Janeiro. A visiting scholar at Max Planck Institute in Germany and Harvard Kennedy School in the US, she acts as a justice law clerk at the Brazilian Federal Supreme Court and state attorney for the state of Rio de Janeiro. Questions can be submitted through our form and they will be shared with the debater. The link is available in the YouTube video description. With the floor, Professor James Folks, followed by Professor Patrícia Perrone.
Well, good morning to our Brazilian audiences and good afternoon to the German colleagues. I'm delighted to be here and thank you for the invitation to participate in a discussion that is a little bit like me. For those of you who don't know me, I'm a South African who is a German law professor, so I have one foot in the global south and one foot in the global north, like this discussion. So although neither Brazil nor Germany are my home systems, I feel rather at home with this format, and so that's very comfortable. And it is from that perspective that I'll be speaking today. I thank Professor Patrícia Perrone for serving as debater or as respondent, and I'm delighted that we have Professor Oscar Vilhena, whose work, among other things, on transformative constitutionalism, I know, to come in the second panel. And finally, thank you to the Supreme Federal Court for hosting us for this event. So our topic today is about countermajoritarianism and about courts. And the nice thing about following a jurist of the statue of Roberto Barroso is that I don't need to say too much about the basics, that he has sketched and introduced the topic for us. And so I want to talk about it in a way that is aimed at complementing his remarks, and I think some of those things that are to come in the second part, by saying a couple of things about the countermajoritarian dilemma that are not always those on which the traditional discussion most focused. We confront the countermajoritarian dilemma right now at a time of crisis, and at a time when there is a sense of crisis, not always the same thing, about constitutions and courts and democracy. And at this moment, the first thing I want to say is to draw a link to populism. Populism is, of course, a form of, allegedly at least, majoritarian argument. Populist leaders claim to speak for the people, as we've heard, and they direct the argument against allegedly counter-majoritarian institutions that are said to have lost touch with the people. And in the standard picture, populists are attacking constitutions and liberal constitutional democracy in general, and courts need to stand as guardians against them, and responsible lawyers and scholars and citizens must help them to do that, right? It's quite a clear picture. It has clear sides, and it's clear which side we are supposed to take. The second point about the countermajoritarian dilemma is that among all the people who've engaged it sensibly, it has always been about striking a balance rather than being about a hard choice, right? It's not a dilemma where we're supposed to pick between the two options, something that has been particularly clear for courts, right? Nobody ever thinks the countermajoritarian dilemma is about courts deciding whether to decide everything in a democracy or whether to decide nothing. Both those options leave no useful role for courts. It's striking a balance. And so it's interesting that the countermajoritarian dilemma is about a balance between two sides, and we understand it that way, while the debate about populism is about a war between two sides. And while there is a good deal that one could say and theoretical nuance one could add to that, for the purposes of 20 minutes, today as an exercise, I want to ask what it might look like to talk about populism in the more striking a balance fashion in which we usually approach discussion of the countermajoritarian dilemma. But before I do that, I should acknowledge the difficulty of doing this. In times of crisis and threat, it can be difficult even to talk about the other side of the argument, even to acknowledge it, because it can seem like a strategic risk. Right? Social reformers who admit that some aspects of the constitutional order need preserving risk blunting their political argument, risk disappointing their supporters and playing into hands of conservatives, and constitutional defenders who admit that some aspects of the Constitution might need changing, risk opening all of them up to attack. Right? COVID has illustrated this problem rather well. Right? For instance, there have been sometimes democratically problematic things about the response to COVID in democratic states. But how do you talk about that? How do you even open up talking about that without enabling or seeming to enable or even seeming to support the conspiracy theorists and the deniers of scientific evidence and those whose irresponsibility has put hundreds of thousands of lives at risk? And as the COVID example also illustrates, this kind of debate, where it's not easy to acknowledge the other side, very easily polarizes. And we see this in the discussion of constitutionalism too. Right? Critics who start with narrower concerns or political movements that start with narrower concerns often escalate to attack the Constitution or liberal constitutional democracy as a whole. And defenders can start treating any criticism of the courts as a threat to judicial independence and any criticism of the Constitution as a threat to the rule of law. And this kind of highly polarized discussion is often very understandable politically. It's not always very helpful as a way to think about the issues. So although there is indeed discomfort and risk in trying for a more balanced view, it can also be necessary to combat this kind of polarization, this escalation to extremes on both sides. It can be useful to do, at least in our own heads. And it is in this spirit that I want to talk about kinds of populism that are not always captured by the standard picture of the Constitution and the courts as guardians against the populist threat. And today I want to mention three: valid populism, constitutionally good populism, and judicial populism. So first, there is the problem that if the countermajoritarian dilemma really is a dilemma, if there really is a problem with too much being decided against majoritarian views by unelected bodies, then populists will sometimes have a point. Right? Call this the question of valid populism, because the criticism that an elite is deciding too much, that it is too little accountable to the true public, that it is not in touch with their issues or has departed from them, diverged from them too much, is both the standard counter-majoritarian criticism of courts and the idea at the heart of populism. Now, a standard response to this is that if judges stick to enforcing the law and the Constitution, then they are exercising delegated democratic power. And so their democratic credentials are in order. Right? In Germany, the ununterbrochene Legitimationskette, the unbroken chain of legitimacy, stretching from the electorate to the court's decisions. Germany, however, is also an unusually good illustration of the problems of this argument. German constitutional doctrine is very broad. The ideas of where and how the Constitution applies are very broad. So there is very little of importance in German life that could not be framed as a constitutional issue. So while it may still be perfectly valid to argue that the Constitution delegates democratic power to judges to enforce, it's much less clear that this argument serves anymore as much of a limit on judicial power. If the text is democratically legitimate, and the text is interpreted by the court to apply very broadly to many things, then very broad judicial action is, by this argument, legitimate. The original idea behind the Countermajoritarian Dilemma, that in a democracy, important decisions should be made as much as possible by elected people and not by judges, risks slipping through the fingers of this argument. Right? And this, of course, is a concern far from unique to Germany. Right? If I took off my German professor hat and put my Global South hat on, I might speak instead about transformative constitutionalism, right? Which has a similarly expansive vision of the Constitution as a blueprint for social change towards a more just society. And if that's so, then constitutional power needs to be exercised in every location that does not match that vision or that might obstruct that vision. And that argument can take constitutionalism to a lot of places. And it can imply that the power and the duty of the courts runs to all of those places as well. The South African scholar Jaco Barnard Nodé has referred to this as the totalitarian implication of transformative constitutionalism. And what risks being lost here is the part of so much of Global South constitutionalism, the part that is about decolonialism, about recovering democracy from military and other authoritarian regimes, the part that is about citizens exercising democratic power, not about courts exercising power in the name of democracy. Neither of these are absolute arguments. To the extent that there's a valid point or a concern in these arguments, however, and I think there is, at least to some extent, then notice that this is a populist critique, or could easily be framed as one. It's a good example of an argument that we may currently worry about making, lest it weaken the defense of courts. But it's also an argument with at least some truth to it. With that in mind, let's move to the second point. Right? Call this the issue of constitutional populism. Right? And by this, I do not mean populism that tries merely to look constitutional. Right? We've heard from Justice Barroso about autocratic legalism, a term coined in the Venezuelan context by Jose Corrales, and we've heard about abusive constitutionalism and abusive constitutional borrowing, a term coined by David Landau, the US comparativist and Latin American specialist, and developed in his joint work with Ros Dixon in Sydney. Right? This is a literature about authoritarian leaders who merely try and look constitutional. It's a little bit like the leaders of one-party states in the past trying to claim the democratic credential of being elected. Right? This is not something that constitutionally we should be taking seriously. But populism can also be genuinely, sincerely, constructively constitutional. This is a way to understand Hannah Arendt's point on revolution. Right? She argues there that most often we think about revolution in terms of the French Revolution or the Russian Revolution, violent, destructive revolutions which destroy institutions to the point of ending in the mass killing of political leaders. But, says Arendt, we should not forget the possibility of constructive revolution, like the American Revolution, a revolution in favor of government, in Max Edling's famous phrase, which uses its revolutionary momentum, which uses its power to establish a constitution and to establish constitutional institutions. Right? Bruce Ackerman, a disciple of Arendt on this point, will tell us to remember the same lesson about populism in his recent book. Constitutions, after all, like populists, claim to represent the will of the people. That doesn't mean that everyone who speaks like this is a sincere constitutionalist. We know that, but it doesn't mean that they're not. There are good grounds for calling somebody like the younger Thomas Jefferson a constitutional populist, for example. I think there can be good grounds for thinking of something like the current constitution-making exercise in Chile as an example of populism. Certainly in its targets, it mirrors constitutional arguments, populist arguments in attacking the existing order that emerged in Chile after the end of the Pinochet dictatorship. And yet, of course, there is much in that movement that is constitutionally rich and admirable. So once again, we have here a difficult argument. Right? We might not like the idea of weakening our defenses against populism or enhancing its legitimacy. But once again, the argument about good constitutional populism or valuably constitutional populism doesn't seem like one that constitutionalists should or would want to reject nearly as directly as that implies. Let me then move to the third point. If, to the extent that there are valid grounds for criticizing the constitutional order, that surely doesn't mean that judges have to wait and hope that a sufficiently good constitutional populist movement comes along to change the constitution. Right? Can't judges be more assertive, more active in their response? For example, one populist concern is about people being excluded or feeling excluded from power, people feeling that they've been forgotten. And we see this in the cry coming from the east of Germany a few years ago, at the time when large numbers of Syrian refugees were entering the country, as expressed by Petra Köpping in the title of her book, Integriert doch erst mal uns, integrate us, the East Germans, first. This is an expression of people feeling left out of the existing constitutional order, of the existing society, of being forgotten or not heard. And if this is the feeling, if this is the problem, why should courts not respond by lowering barriers to access for ordinary people, by publicly trying to engage their issues, by operating in a more openly democratic fashion that involves more listening and deliberation, and less just handing down an order and expecting it to be obeyed? Right, Roberto Gargarella, at the end of his long-run account of the tensions within Latin American constitutionalism in the engine room, is notably interested in strategies for opening up courts, including devices for easing access like the amparo and the tutela. And the Brazilian Supreme Court, as we know, as we're using this afternoon, is known internationally for how much it uses radio and television and live streaming. Similarly, why should courts not try to address the more substantive causes of populism as well? In Global South constitutional discussion, for example, it's a standard concern that courts should do more to engage issues of poverty and inequality and corruption, which are often the issues that matter the most to the people in their societies, and often the issues on which the success or the legitimacy of the current constitutional order gets judged. Isn't it more appealing to talk about this kind of positive, proactive response than the role that courts can sometimes be assigned by narrower versions of militant democracy, for example, where their role is about deciding whether to ban parties that threaten the democratic order? Right? Both the Brazilian and the German constitutions allow for the possibility of party banning, of course, but they also provide a basis for courts potentially to do so much more. Now, I think these arguments will sound a little more familiar to the Brazilian listeners than to the German ones. Right? Compared to other systems around the world, for instance, German constitutional law pays rather little attention to debates about dialogue, weaker form review, or procedural creativity in the way that a court conducts its business. But my point is that whatever you think of these arguments, let's notice what they involve. And let's notice what they involve, especially when this kind of action from courts is seen as a response to populism. Right? These arguments have a good deal to do with how courts are seen as listening to the people and as engaging with their problems. They are, in fact, or they can be, populist arguments. This is a strategy of judicial populism, with a court purporting to be the institution that truly hears the people and that truly looks out for their interests against the powerful. Perhaps the starkest example of this kind of judicial calculus is the Indian Supreme Court's move to recover its legitimacy and restore its power after the emergency. Right? The emergency is the brief suspension of India's democracy under Indira Gandhi in 1975, lasting into 1977. And the response of then Chief Justice Bhagwati was to borrow Indira Gandhi's political strategy, to appeal directly to the poor, to try as publicly as possible to throw open the doors of the court and let the issues of the poor inside, and to try as hard as possible to be seen that way. Now, a great deal of sincere interest and value came of this move, which became the Indian PIL model, public interest litigation, known no doubt to many in the audience. Right? I'm certainly not attacking the model, generally speaking, but it was a populist strategy, and it did bring the dangers of populism with it. Populist arguments always resist institutionalization, which is why the older Thomas Jefferson, once he became an official and a president, got much less populist. The Indian Supreme Court, under the PIL model, has been notable for its lack of doctrine, its decision often not even to issue written judgments at the end of many of its interventions, and with the extent to which there aren't really very visible restrictions on when judges will intervene or to what ends, beyond what a judge happens to feel is in the interests of the people. So when we criticize populism, it's worth remembering that those criticisms can apply to judges too, and that they might apply particularly strongly to the kinds of responses from courts that are sometimes suggested as the best way for judges to respond to populist threats. So these are the three issues. Navigating the counter-majoritarian dilemma, it seems to me, has always meant trying to decide when judicial intervention is avoidable or when it's necessary. And it seems to me that in the age of populism, in our current moment, that task means it includes having to try and identify those of the populist concerns that are valid. It means we have to remember the possibility that some populism can be constitutionally good or supportive. And it means we have to remember that judges too can be populist or can behave that way or adopt strategies that operate on a populist logic. And it means we have to do all of this while continuing to reject and discredit the invalid populist concerns, while still opposing populist attacks that erode constitutional democracy, and while still supporting judges and courts who present key institutional mechanisms in this effort. We have to do this while remembering, as the Ukraine has sadly taught us, that some of the time the goodies and the baddies are very clear. All of this is hard to do, but then no one has ever pretended that the counter-majoritarian dilemma was an easy one. Indeed, for all the best people who've thought about it and written about it, it was never meant to be a dilemma that we answered. It was never meant to be a choice that we made. It was rather meant to be a constant reminder against erring too far to one side or to the other. And at the present moment, none of its lessons might be more important to constitutional lawyers than that one. With that, let me thank you again for your attention and for the invitation to be here, and I will hand over to Professor Patrizia Peroni.
Good morning or evening to you all, depending on where you are. It's quite an honor and a joy to be able to participate in this seminar, and I would like to specifically thank the Secretaria de Altos Estudos of the Brazilian Supreme Court for this invitation. As it has already been mentioned, I have the role of debating on Professor James Folk's ideas, and I would like to do this in connection with the ideas also expressed by our keynote speaker, Justice Barroso, because I really think that although you have not used the same concepts, I think that your ideas are very convergent. So I would begin with three concepts. I would speak very briefly about the counter-majoritarian role of the constitutional courts. Then I would go to the representative role mentioned by Justice Barroso, and then to the constitutionally good populism proposed by Professor Folks. So first of all, in what concerns the counter-majoritarian role of the courts, when we say that the court is delivering a counter-majoritarian role, a counter-majoritarian decision, we actually are saying that it's invalidating an act or a decision from the political branches. And then the problem is how to explain that members of non-elected members of a constitutional court can invalidate acts of political branches whose members are elected by the people. Is this democratic? This takes us to the idea of the constitutional courts also playing a representative role that was mentioned by Justice Barroso. The point is that sometimes a court can be either counter-majoritarian in the sense of going against the political preferences of the executive or of the Congress, but at the same time be representative in the sense that it's aligned with the preferences of the majority of the people. So this makes discussion a little bit more complex, because is it undemocratic for a court, even composed of non-elected members, to be responsive to the concerns of the people? Is it undemocratic to a court, even composed of non-elected members, to be protecting the rules of the democratic game? So I think this was an issue brought by Justice Barroso, and I think that it dialogues a lot with the idea of constitutionally good populism and of judicial populism brought by Professor Folks. Professor Folks says that we have a crisis. We have a democratic recession all around the world. And if we have a crisis, we have a problem. And therefore, we should address this problem. We should try to understand why we are experiencing this democratic recession globally. And I believe that one of the answers to that question is that people don't feel represented, and that there is an impression that democracy is not delivering a relevant part of its promises, like delivering good quality public services and being able to guarantee a minimum dignity and equality for all the people. So this is an issue of not feeling represented and not feeling that the popular interest is being, that the political branches are responsive to these interests. And then comes the good and the bad populism. The bad populism meaning the try to entrench in the constitution an authoritarian way to run the government, and the good populism, which would be an effort from the institutions, from all of them, including the judicial branch, to be responsive to the concerns of the people. So I think that this concept of constitutionally good populism and of judicial populism is very much connected with the concept of the representative role of the constitutional courts, because being judicially populist, at least in the sense I understood, meant being representative in the sense of being responsive to some of the popular demands. And then it's connected to the idea of transformative constitutionalism. Also, as Professor Folks has mentioned, we have several constitutions, especially in the global south, who are very concerned about this transformative role of the constitutional law. And so these constitutions, they express a transformative goal. And so why wouldn't the judges which are applying these constitutions make these goals concrete? Why wouldn't they try to advance in a more progressive direction, since you have a constitutional basis for that? This is a lot pertinent to the Brazilian experience of constitutional law. I'm not saying that we're perfect here, not at all. But I think that we have a few examples of this representative role of the Brazilian Supreme Court and of our courts in general, and of this constitutionally good populism exercised by the courts. So for example, we have a constitution, our 1988 constitution, that established several social rights, like the right to public health for all, the right to public education for all, the right to housing. And the judicial, the political branches, they didn't immediately enforce those provisions. Worse than that, they are still not plainly enforced. And in a certain way, the judicial Brazilian branch had a very important role in trying to push for the application and for the concretization of these rights. You could say that the Brazilian courts in general are very much responsible for the expansion of health services, for example, although we still have a lot of problems concerning the matter. The second example would be the actuation of the Brazilian Supreme Court during the pandemics. We had a federal government which was considerably resistant in taking some relevant measures, like, for example, determining social distancing and isolation, the use of masks, and even concerning the vaccination of the Brazilian people. And we were able to face the difficulties generated by this resistance, in part through decisions from the Brazilian Supreme Court, who supported these measures. It is true, and this is also part of what Justice Barroso mentioned, the Brazilian Supreme Court was not alone in that. So the states, since we are a federation, our states were passing laws and editing decrees determining those measures that were being questioned in the Brazilian Supreme Court by the federal government. And the Brazilian Supreme Court upheld those measures, and in this sense helped to protect the right to health of the people. The same thing with the Congress. The Congress approved several measures and passed two laws which were very important for offering support for poor people, and those measures were also supported by the Brazilian Supreme Court. So in a way, the Brazilian Supreme Court was fundamental to guarantee the legitimacy of the measures that were being questioned by the federal government. And on the other hand, it was not acting alone, what shows that really if you want to fight against rights recession and democratic recession, what you really need is to have several democratic watchdogs working together. If you just have courts are going to be packed. So in conclusion to these observations, I would say that any branch can be responsive or abusive. So the democratic protection in the long run might be possible with a healthy interaction with all of them. Maybe this is the best strategy, and not thinking of a hierarchy between the branches. So these are my main observations on Professor Fogg's lecture. I hope they are loyal to what he tried to express. And I have two questions to present to him that we received from our people. The first questions come from Maria José, and she's asking about instruments that could make citizens closer to the courts. Professor Fogg mentioned the TV broadcasting. She asks about if he is aware of our Amici Curiae, and about our public hearings, and if these instruments would be instruments that could make citizens closer to the courts. And Alessa Sunisono asked about actions that could be taken by the courts to the protection of democratic regime. Please, Professor Folks.
Thank you, Professor Patrizia, and thank you to the questioners as well. So let me first say that I think I agree substantially with the idea that there is a lot of alignment between what I was trying to say and what Justice Barroso was trying to say. That indeed was very much the idea. It's merely that I think it's useful, perhaps for our own thinking, but also for some of the debates, at least that we have in a scholarly community, to keep these other possibilities in mind when we are trying to think about the issue of populism and courts and constitutions, right? The difficult part is about how to do that when we recognize that I would have little against anything that Justice Barroso said, and when there was much truth and wisdom in it, right? The difficult part is about where the limits of those arguments come, rather than with the arguments themselves. And that's the part that I'm trying to speak a little bit about. One of the ways in which we might think about how to do that, since you mentioned the socioeconomic rights jurisprudence, is about trying to think about ways in which courts can intervene usefully in that area, while also trying to respect majoritarian institutions, to respect the legislature, and indeed more actively to try and use their intervention as courts to prompt and prod and nudge and improve the processes in the legislative context. And there are some useful German examples for this. Sadly, socioeconomic rights is one of those issues where sometimes the global South thinks the global North has nothing to say, as the global North quite often seems to think about the global South on other issues. But the German court's interventions are a good example of where there are things that might be useful in how social rights are regulated, because much of the response is about procedural protections, about the process that the legislature has adopted, for instance, famously in the process of calculating the amount of social grants in Hartz IV and in the asylum seekers decision subsequent to that, and the procedure more recently in a decision on the conditions for forfeiting your social grant when you lose a social grant or it is withdrawn for a failure to comply with the conditions. Right? These are good examples of places where courts can scrutinize the details of the procedure that the legislature has followed, the way in which the decision has been taken. It's a familiarly court-like way to proceed that reminds us of administrative law. And it is a way in which not only courts can respect, but also try to improve and nudge and prompt intervention. Right. Justice Barroso, of course, has raised the problem that that argument isn't always available, that the legislature may not respond to the prodding or it may stay inactive. And when there is a failure by other institutions, then courts have a harder time. But there is plenty of room before that point to think about interesting possibilities. Certainly, I also think, incidentally, that Professor Perrone is entirely correct to talk about the need for several watchdogs, that arguments that rely on courts are always wide of the mark, especially as we add more and more of these bodies. To the questions that came in, they're both very good questions, but also very broad ones. Certainly, when I talk about ways in which courts can bring citizens closer, I do mean things like the use of public media and the use of social media. And there are lots of interesting and innovative things being done by courts around the world in this regard. Some courts have Twitter accounts, for instance, and some courts use memes and things of this nature, right? And as we've said, the Brazilian court does a great deal in this kind of area. Certainly, amici curiae are another important way to proceed. And you may be interested in the fact that Justice Bhagwati, whom I mentioned, and his intellectual ally, Justice Krishna Iyer, talked about the need for citizens who were more resourced or in a stronger position socially to act as socio-legal entrepreneurs for the issues of the poor, right? They didn't think that courts would be terribly successful in getting the poor directly to be active in the courts. They did this to some extent, right? Poor people writing letters would have the work of turning that into a petition taken over by the courts. But mostly it wasn't that. Mostly it is about having intermediaries, about having representatives. And certainly the amici tradition is tremendously important in that kind of regard. So there are things in this area where courts can do things, but the kinds of things the question raises are certainly the things that I'm talking about. Those two pieces, what I've said about socioeconomic rights and what I've said about ways of relating to the public are probably at least two of the important answers to the second question about how courts can react to these kinds of concerns. There are certainly two good ways to think about. But certainly, if I was to add a third piece there, it would be the importance of institutional relationships. And this takes us back to the question of the need for several watchdogs. That courts in difficult times are invariably, like the rest of us in difficult times, needing to draw on established sources of trust, established relationships with other institutions, with other politicians, and that is a lesson for us to remember when crises go away and it's an easier time. Because it is sometimes easier for courts, it sometimes seems easier for courts to intervene here, there, and everywhere, to act. And when they do so, they might be forfeiting trust. They might be forfeiting opportunities to say to the legislature, yes, constitutionally, you're handling this in an admirable way. We respect that, right? That kind of thing builds up a form of social capital, which courts can then use later on at times when they need support from those institutions and from those people. Those are the relationships that are crucial. Insofar as the counter-majoritarian dilemma is sometimes written about the court standing alone, it is wide of the mark. And it's when courts stand alone that they often fail. It's when they stand together with partnerships that they have worked to build that they have the best chance of surviving. With that, I will hand back, I believe, to our chairperson to take us to the next panel. But thanks so much again to everybody, and thanks particularly to Professor Patrizia Peroni.
Now, we'll start the second panel of our webinar. The second panelist will be Professor Oscar Vilhena Vieira, and his debater will be Professor Joaquim English. Professor Oscar Vilhena Vieira is Dean of Fundação Getúlio Vargas School of Law in São Paulo. He holds a master and doctorate degree in political science at the University of São Paulo and postdoctorate at the Center for Brazilian Studies, St. Anthony's College, Oxford University. He was Human Rights and Latin America Counselor for the Open Society Foundation. He was also founder and director of Conectas Human Rights, Pro Bono Institute, and the Global League of Law Schools. He is a columnist for the Brazilian newspaper Folha de São Paulo. Joaquim English is a tenured professor for public law and tax law from University of Münster and managing director of Tax Law Institute of University of Münster since August 2011. Professor English serves as appointed member of tax expert groups with the OCDE and the European Union Commission and advises national governments. He is also visiting professor in several national and international tax LLM programs. Please note that questions can be submitted through our form and they will be shared with the debater. The link to the form is available in the YouTube video description. With the floor, Professor Oscar Vilhena, followed by Professor Joaquim English.
Good afternoon to all of you. I would like to thank immensely the invitation to be here. It's an honor to be here. I would like to stress this to the President of the Supreme Court and also to Livia, who coordinates the Center of Studies at the Supreme Court. It is also very nice to be here with Jane Folks and Joaquim English and my dear friend Patrizia Peroni to discuss this issue that is so dramatic at this moment when we are living under a wave of authoritarian populism in many parts of the world. So my idea, after all this wonderful presentation by Justice Barroso and this very sophisticated debate proposed by James Folks and Patrizia Peroni, I think if Joaquim English agree with me, I will try to provide a more fact-oriented debate about the Brazilian case. And I will put a PowerPoint here, if I can, to help me present some figures and images that I think will help the foreign viewer to understand what is probably going on in Brazil. So let me see if I found okay, so I do have here. Are you seeing my screen? Hello?
Yes, we can see it.
Okay, so let's start. So my first, it's not moving. There's always a problem here. For some reason, it's not moving, my PowerPoint. Let me try again. Okay. The applicants cannot see your application, said here. Nope. Flavia, perhaps there's some problem. If you could, I will take it out my presentation and you insert it from there. Is it possible to do this?
Sure, Professor.
Okay. All right. So we can move to the second and perhaps put in the presentation form. Okay. And go directly to the first slide. Could you put in the second slide? Yep. Okay, let's abandon our presentation because it's not working. I can handle. I have done this before. Okay, so just for us to settle the debate about the challenges for a Supreme Court to deal with a populist government, I wanted to insert this debate on the Brazilian constitutional system, which is peculiar for some of those who are probably watching us. So Brazil adopted a new constitution in 1988. This constitution was a result of a long transition that had around 9 years. So when the Constitutional Assembly finally met to produce a constitution, this was a very different assembly that we were accustomed to do in the past. Brazil has done several constitutions in its history. Most of them were produced by jurists and then reaffirmed by an assembly of politicians. Probably like many of the constitutions that were done around the globe in the 19th century, but also some of the very good constitutions done in the 20th century, as the German Constitution, or as the South African Constitution, that was very scrutinized by technical assistants and intellectuals in South Africa. The case of the Brazilian Constitution is absolutely different. It was an enormous assembly. There was no roadmap for the Constitution, and there was a lot of distrust among those who were participants in the Constitutional Assembly. So this resulted in what I call a maximized compromise. So when you have enormous distrust in people that are contracting with each other, there is a tendency that the contract is very detailed. And that is how the Brazilian Constitution in detail arranged all the compromises that were done during the transition. So it is a reactive constitution against a background of authoritarianism, but also is a reactive constitution against a more profound background of inequality, underdevelopment, poverty. So it's a constitution that is very ambitious in its goals. That's why folks said that I've been working on the transformative constitutionalism, which is, in some sense, the Brazilian constitution is part of this family that put in the constitution the responsibility to transform society, which is an ambitious responsibility to put on the shoulders of constitution. But also there is a characteristic that my friend Daniel Sarmento said. The constitution became very ubiquitous. So it regulates every sphere of the Brazilian life. So what we have here is a package of an ambitious and ubiquitous constitution that resulted from a distrustful pact where people try to insert in the constitution all their interests and all their aspirations. Regarding the political system, and this is very important for our debate on counter-majoritarian, the constitution is very consensualist in the terms posed by Aaron Lippert. So the constitution fragmented the power in several instances. So if we take our engine room, it is a coalition presidentialism because we elect the president directly, which is supposed to put power in the hands of the executive. However, it builds the legislative in a way where the power is very fragmented. We have plural partidarism, very fragmented party system. We have proportional representation with reinforced party fragmentation. We have bicameralism. So even in this 30 years, all the presidents that were elected, they never had a party that was dominant in the parliament. They have to build coalitions. At the beginning of our redemocratization process, President Cardoso built a coalition with 3 parties. President Dilma, before she was impeached, she had 13 parties on her coalition. So it was not just a fragmentation that moved on. I will not discuss this with you. And also the heterogeneity of the coalition. So you have parties from the right, from the left, to build such a coalition that provides a majority for the president. So in Brazil, it is very hard to be majoritarian. You need to dialogue profoundly, intensely with a parliament that per se is the first instance of counter-majoritarianism in Brazil. So this is a point. Obviously, Brazil also, not obviously, but the constitution also reinforced the federalism, which is also a counter-majoritarian per nature instrument, and it reinforced the role of the Supreme Court. The Brazilian Supreme Court historically has been a very autonomous and independent agency. It played the role similar to the US Supreme Court as a last appeal tribunal. However, in 1988, as the constitutional pact was being built under such distrustful atmosphere, the power of the Supreme Court was extremely reinforced, so the Supreme Court could be, in some sense, the guarantor of the pact. So this, what do I mean when I say the court was reinforced, has reinforced its powers? I'm saying that what traditionally in other democracies are 3 jurisdictions. You have a constitutional court, you have a court of appeals, and you have a distributed jurisdiction regarding how you punish authorities. in Brazil, they were all concentrated in one court. So in fact, what I call supremocracy is a result of the concentration of activities in the hands of the Supreme Court that today is a constitutional court, is a court of last appeals, and is a court that trials every major authority, including members of parliament, if they committed an abusive use of their power or if they committed a crime, which means that the elite of the Brazilian politicians are in the hands of the Supreme Court when they commit something wrong. And finally, the Supreme Court has the capacity, explicit capacity, to control amendments to the Constitution in a very vast, large group of what we call entrenched clauses. That means that the Supreme Court provides the last word in the major issues regarding the Brazilian political system. So if we could go to the next slide. So this system functions pretty with stability until 2013, when the Brazilian, mostly the youth, originally went to the streets in large protests that took cities around the country. It's interesting. It's a very paradoxical moment because part of these demonstrators that took the streets in 2013 were claiming for the unfulfillment promises of the Constitution that Patricia mentioned before. They were saying that the school was not good enough, that the quality was not sufficient, that the health system was not adequate, and that there was a necessity to improve the quality of the representative government, that there was a necessity to improve the quality of the rule of law, because it was so unequal, the distribution of justice in Brazil. However, after 2014, the streets began to change its position, or those who came to the streets were claiming a different thing. And partially they were in the helm of what James folks mentioned. They were people with resentment of what the Constitution has done. So the Constitution has transformed some social relations, the role of the woman grew, the Constitution recognized that there was racial discrimination in Brazil, so there was several measures as affirmative actions providing compensation for those who have been traditionally discriminated. So it's an interesting moment because the Constitution malfunctioning receive reaction from those who still think it was not enough. And the conservative sides of the Brazilian society were claiming just the opposite. The Constitution went too far in providing social transformation. So this opened a space for a huge polarization of the Brazilian society, as we have not seen since the military regime. So there was a clash of narratives about how the Brazilian society was being organized by this constitution. There was a new far-right movement that appeared in Brazil that galvanized both conservative evangelicals, the military that were deposed in the end of the authoritarian regime, and new right, which was very influenced by the far right in the United States. People claiming to have guns, people claiming to have absolutely right to offend others. So it was an Americanization of the Brazilian debate and a polarization of the Brazilian debate. Obviously, that this led to a more polarized conflict among the political elite, which resulted in the end on the impeachment of President Dilma Rousseff, the president elected by the people, but that decreased her support in the population along her second mandate. Also, there's a very important event which was the car wash operation, an operation investigating corruption and finding systematic corruption schemes to support political parties, involving most of the political parties in Brazil across ideologies. However, the party who was in power at that moment received most of the pressure of the car wash operations. I describe these two major institutional events, both the impeachment and the car wash operation, as examples of extended hardball. So the Brazilian political system entered in a cycle of institutional retaliation as a result of the destabilization of the political force started in 2013. So the Brazilian system, even though I do not consider a constitutional crisis because there was no violence, so the conflicts were channeled through institutional channels. However, these institutions were behaving in a very unorthodox way, probably abusing of some of its prerogatives to offend adversaries or to aggrandize their own power. So that's what I call the clash of powers, or the cycle of institutional retaliation. Obviously, these created increasing distrust on the institutions and open a space for populist discourse. So, just making a footnote here, I think we can pass to the next slide. Okay, so it's interesting just because you also debated the nature of populism. Obviously, populism is an old word from the Thomas Jefferson could be considered a populist. It's a vacant word, open vessel, and signifies different things in different moments. But I will make just a very simple scheme in the sense that there are inclusive populists and exclusionary populists, as my friend Helena Alvear uses to say. But if you don't like Alvear's classification, you can take Pope Francis' classification. Well, there are good populists and there are bad populists. However, what we are seeing, and I think not to occupy much of the time here, we are passing through a wave of authoritarian populists, in the sense that these populists are anti-pluralist, they are anti-institutions, and normally they are trying to exclude rights from vulnerable groups in the political system. So this could unify those in Hungary, in Poland, in Turkey, and in India, and in Brazil, and obviously Donald Trump. In this perspective, if Brazil elected an authoritarian populist that belongs to this family of exclusionary populists, the question is how the Supreme Court, that was strengthening since 1988 its power, and exercises this power during a period where most of the politicians were absolutely committed to democracy. So they never challenged the core of constitutional democracy. So the Supreme Court exercised a large portion of its powers, but not in its limits. The question now is that the president who was elected in his political campaign challenged the Constitution itself. One of his catchwords was, "I will end all of that we have until now." So he's an anti-system president. So how the court deals with this kind of a challenge? It's not just a majoritarian challenge. It's a majoritarian challenge coming from someone who is not committed to the values of the Constitution. And I think this is really the problem. So I move to this slide that is in front of you. What do I want to show? No, I'm sorry. Go back to the last one. So what I want to show. No, I think the no, back. Perfect. Okay. So what I want to show to you is this. All these presidents in Brazil, they had to create large coalitions to put in practice their plans of government. And if you measure the level of success of this president by what they approve in Congress, we see that President Bolsonaro is the weakest president we have in the line of those elected in Brazil. Okay, so his level of his success rate in approving the bills is 31% against 46 of President Cardoso, 47, 67 of President Lula, and 49 of President Dilma. What is in this 31% that he approved? Most of all are ordinary laws related to budget, which is 25% of ordinary action of the Congress in Brazil is approving budgetary regulations and laws. So basically what I'm saying here is that Bolsonaro didn't approve anything. He has approved one large amendment to the social security system that was produced by the former government, that was in some sense a consensus among the political parties, taking out the left, and it was approved. But besides this, Bolsonaro wasn't able, even though Congress passed 12 amendments in this period, none of the amendments were produced by the government. They were parliamentarian amendments, and that are not related to the core of the Constitution. Okay, so he is a weak president because he doesn't control Congress, which is the major counter-majoritarian instrument in the Brazilian democracy. If you pass to the next, so how he react to his impotence as a president in a presidential system that is unable to pass laws that would implement his far-right proposals or far-right ideologies. Well, basically, he decided to move to something that also Trump did with intensity, which is trying to neutralize the progressive constitution, try to neutralize the progressive legislation in the areas of interest of his supporters through executive orders. So, and it's very interesting here that he is the champion in terms of edition of decrees in Brazil if compared to the other presidents. So he was impotent to pass laws, but he was very aggressive in terms of producing decrees. And what are these decrees about? Most of these decrees are related to some thematic areas, environmental issues, indigenous people issues, gun control issues, and other issues regulating rural property. So these are the areas of interest of this government. And what are the content of these regulations? Most of all, they transform some of the missions of the federal agencies responsible for implementing these policies. So he altered the functions of the environmental agency. So this is and the composition of the commissions or the councils of these agencies. So basically what he was doing is occupying the state, occupying the agents, and altering their functions. And in this way, it was trying to neutralize the legislation that his supporters accused of being too progressive. So that's why I don't use the terms abusive constitutionalism or authoritarian legalism. What is happening in Brazil is basically an infra-authoritarian legalism strategy. And this infra-authoritarian legalism strategy is based on abusive use of executive prerogatives and also in the use of what I call para-institutional orders. Since Bolsonaro knows that some orders are illegal to be given through institutional channels, he gives orders to the Twitter, he gives order to the radio conference, and those who were appointed by him and heading these institutions, they can understand these orders, which are being given daily through anti-institutional or para-institutional means. So it's interesting, this second strategy of Bolsonaro. It's very, I will give one example. The Brazilian legislation authorized if you caught a machinery in the middle of the forest, destroying the forest illegally, that you can destroy the machinery. That's the legislation by the administrative agency. Because it's impossible to take out this machinery in the middle of Amazon. The cost of apprehending the machinery is too high. So the administrative agency has the power to destroy. So he just say in a radio interview, if someone in my government destroy one machine, he will have to talk with me. However, the head of the environmental agency is a former colonel that understands and provide orders to his agencies not to implement the law. So this is the way, in some sense, Bolsonaro is eroding the constitutional normativity in Brazil, not by altering the norms, not by altering the constitution or the law, but by neutralizing it through infralegal measures. So if we can move to the next slide. So how the court reacted to it. In the first year, the court was very different and very quiet and very, I would say, not omission, because there are some important cases decided in 2019. However, the court was very hurt by the previous period where this clash of powers that happened during the impeachment process, during the Operation Car Wash, the court was hurt in its legitimacy because the court participated intensely in this project. So the court was very criticized by the left because the Operation Lava Jato hurt the left, and the court was very criticized by the right because the court was always very progressive in defending minorities. So this led the court to a very weak position in the beginning of the Bolsonaro government, and this perhaps justify a more quiet posture in the first year. However, we started to see with the aggression of the far right to the Constitution, to the Supreme Court, that the court started to react. And the first sign of this is the number of cases that arrived to the Supreme Court in 2003 and how fast it started to respond to these cases. So it's interesting that it takes for a decision in the first year 376 days to decide a case that were docked in 2019, and this number drops to 76 days for the cases that started to arrive in 2020. So the court became extremely rapid in answer to this. And I will move to my last slide. So the interesting is that the Supreme Court started to be very attentive to those who were trying to attack democracy, and most of all, that were attacking the court itself. So he started several investigations, about fake news. So it played the role of a militant democracy court, protecting the institutions against the attacks from those who are not committed to democracy. So this is one side of what we have seen in the Supreme Court and the Electoral Court in the last few years. The second side was mobilized after the beginning of the COVID-19, where the Bolsonaro government took a very conservative path, first ignoring the pandemic, second trying to boycott the vaccination, third trying to boycott all the measures, the preventive measures as use of masks or decision to close the commerce. And then the Supreme Court came and very strongly vocalized both adherence to science and transferring power or strengthening the power of governors and mayors. So federalism played a very important role in keeping political spheres, the other political spheres in the game to counteract the majoritarian Bolsonaro. So I know that I've been speaking for more than I was expected. So my idea is that counter-majoritarianism, it's not an abstraction. Counter-majoritarianism has to be read in the context of what are the challenges to democracy in a certain moment. And in Brazil, at this moment, the challenge comes from an authoritarian populist, and Brazil counts with a structure of a consensual democracy, a very strong consensual democracy, where these checks and balances are, until this moment, functioning well.
So I think I will continue. I hope I can be heard. Well, I would like to first thank the Supreme Court and the organizers in both Brazil and Germany for inviting me to debate the presentation of my eminent colleague, Professor Oscar Bilhena. And I think his presentation has clearly shown the specific justification, but also risks of a counter-majoritarian protection in the context of a democracy where authoritarian populists have come to power. And the experiences of Brazil and other such countries provide valuable lessons for navigating the general counter-majoritarian difficulty in such circumstances. Now, considering the time, I would like to discuss only two of my ideas here. My first conclusion in light of what we have heard is that when a democratic society is faced with this challenge of authoritarian populism, a constitutional court should probably choose its battles wisely. So I would call this a plea for adaptive counter-majoritarian activism. This means, firstly, that the court should focus on the acute and primary challenge for society under a populist regime, meaning the protection of democratic processes, democracy-enhancing liberties, and the fundamental rights, especially of vulnerable groups. And this then also implies that the court should, at least temporarily, be very cautious to pursue a general progressive agenda of social engineering in those times that is unrelated to the protection of the core democratic values under attack. Especially to engage in what Justice Barroso has referred to as the enlightenment role of the court. Courts have only so much political capital that they can spend, and I think it should be spent on the pressing issues of the time. Of course, this may then be more difficult with a constitution that is very detailed and also very ambitious regarding its transformative agenda, such as Professor Vilhena has pointed out is the case in Brazil. But I still consider such prioritization necessary in order to uphold the constitutional order as a whole in the long term. And from the data that Professor Vilhena has provided us on the reaction of the court to the challenge of the current president, I think the right focus has indeed mostly been chosen in Brazil. And even within this required focus on the imminent dangers to democracy, restraint is, in my view, advisable in cases where violations of constitutional guarantees are not or not yet obvious. This is to ensure that when the court does have resort to counter-majoritarian intervention, it either resonates with predominant public opinion or can at least be explained in strong and persuasive constitutional terms. Now, this avoids giving fodder to the populist narrative of the establishment versus the people. And I think it also relates closely to what Justice Barroso has referred to as the representative role of the Constitutional Court. Of course, the difficult question for any constitutional court is where to draw the line on what is an obvious violation of the constitutional guarantees, so where it can be sufficiently confident to step in without meeting too much resistance or creating too much counter reactions. And this is certainly a fine balancing act, but I think it can be greatly assisted by comparative constitutional analysis. This can either be a classical comparative analysis of law. So, for example, what term limitations are considered acceptable in well-functioning democracies with similar systems of government, and is then the contested constitutional amendment that would extend such a limitation for the sitting president within or outside this spectrum. But also an international empirical comparison can be helpful in some cases. So, for example, let us consider that a populist government supported by, as is often the case, paradoxically, certain parts of the financial elite would wish to lift restrictions in campaign financing. In this case, it might then be useful to make an inquiry on behalf of the Constitutional Court if called upon to judge whether such restriction lifting is constitutional, to make an inquiry as to whether similar restrictions that are in place in other countries have promoted or reduced democratic discourse there, so as to derive arguments that are clearly founded in what we find in other systems that function well, and to strengthen the argument and strengthen the confidence in the strength of the argument by doing so. In my view, Brazil and other democracies on the populist attack furthermore offer a second lesson that has also already been mentioned. It is frequently possible to circumvent or reduce the countermajoritarian dilemma, and the court should make use of those opportunities. This applies in particular where the Constitutional Court can bolster the position of other institutions that have a stronger democratic legitimacy than the court does, and that enjoy the support of what I would call alternative majorities. Now, this is typically possible due to the Constitutional Court's role as an arbiter in the context of horizontal and vertical separation of powers. Vertical separation meaning a federalist system, as has been pointed out by Professor Vilhena and also by Professor Patricia. But in my view, there is more to this than just having several watchdogs besides the court. It is essentially about the court enlisting additional democratic legitimacy for its attempts to curb the excesses of populist authoritarians, borrowing the democratic legitimacy of those other institutions in their attempt to do so. And I think in this regard, Brazil is a particularly encouraging example, because on the one hand, the constitution provides for many such counter-majoritarian institutions, strong Congress, bicameral system, a strong system of federal government. And on the other hand, the president has apparently not succeeded in co-opting the legislative branch, nor state or municipal governments, as Professor Vilhena has very clearly demonstrated to us. And as we've heard, the Constitutional Court has indeed stepped in to uphold the powers of those other institutions, which are directly, democratically legitimized by certain majorities, when they try to protect the democratic system or fundamental rights. And in particular, the Constitutional Court can then also support those other institutions in their struggle for transparency and democratic accountability, which is also something that is usually a sharp sword in the struggle against populists, for example, as apparently has been the case in Brazil, by enforcing the right to parliamentary inquiries by the opposition. Now, conversely, and here I may be slightly critical of a few things that have been alluded to, conversely, I think a constitutional court should avoid to further increase the counter-majoritarian dilemma by overstepping its traditional role as an ultimate arbiter and thereby be perceived as a partisan actor in the power struggle, because this may then seriously undermine its authority and make it vulnerable to populist attack. So, for example, while I do not know the details, and so there might be reasons that are not known to me, I am, upon such superficial insight, somewhat skeptical as to the merits of the Brazilian Constitutional Court apparently launching investigations on its own motion into presumably unlawful or unconstitutional government actions. In my view, at least, as other independent agents still exist that could initiate such investigations, as, for example, a prosecutor general, this should be left to those agents rather than being done by the court itself. Another and related form of sidestepping maybe the counter-majoritarian dilemma consists in enlisting lower courts in the struggle against certain populist dangers at a level where prima facie we're only talking about individual actors that are being involved, so the counter-majoritarian issue doesn't present itself as such. So, for example, the Constitutional Court can require lower courts to restrict the right of freedom of expression in order to protect another constitutional value, namely politicians' personality rights, for example, in the case of social media hate speech. Now, this can prevent the degradation of the political discourse and the intimidation of the political competition. And indeed, in Germany, we recently had a good example for such an approach taken by the German Constitutional Court in the face of initial weak responses of lower courts against, grave assaults against a certain German politician in social media. Another area where the counter-majoritarian dilemma or approach how to reduce the counter-majoritarian dilemma in certain instances, even if it can't be fully avoided, is through preventive measures, certainly. So, for example, populists are well known to have a taste for referendums, and it then would seem preferable to prohibit a referendum already in its planning stage if such a referendum, if it were successful, would bring about serious damage to democratic institutions or processes or violate fundamental rights, rather than to stop the implementation of such a referendum once it has been carried out and actually enjoyed popular support. This is then much more difficult because then it is actually almost more than a counter-majoritarian dilemma. It's the court versus the people. But regarding any such preventive measures, again, I think this is a fine line to be tread. And once more, I would like to point out that in my view, it should be done only in clear and obvious cases. To give another example that we've heard of, barring a president's pick for leading a certain federal agency, barring such a pick from assuming office because this person lacks basic formal competences required for the job, certainly defensible, and is something where counter-majority action can be well defended because it will typically then also enjoy popular support. Doing the same thing because of this person's political views or his or her personal proximity to the president is, in my view, less advisable. Now, this might indeed then open up opportunities for what Professor Villena has called attempts of infra-legal authoritarianism. But it is, in my view, still better to intervene in such instances only when this subversive person subsequently actually and clearly violates the rule of law, rather than based on this person's political beliefs or, as I said, proximity to the authoritarian ruler. And finally, and with this, I would like to end. I think Brazil, the UK, and others show that indeed no democracy is immune against populist challenges. This implies, in my view, that counter-majoritarian judicial review regarding not only fundamental rights, where it's not so much disputed, but also regarding democratic principles and processes is appropriate also in calmer times, in times when the democracy is functioning reasonably well. We need a counter-majoritarian reserve also in this regard to be prepared and ready when a populist assault on our democratic institutions and processes actually occurs, or ideally to already prevent this from happening in the first place. So these were my observations, and I think we do have a few questions in the chat. I will have a quick look. Yes, there are some. So I will start with a question by Alessa Zumizono, who asks, Professor Oscar, in your article, Authoritarian Populism and Constitutional Resilience in Brazil, you say that in the transition from the military regime to democracy, Brazil established a robust consensual political model and a list of unamendable constitutional clauses, among other counter-majoritarian devices. Even so, as you have also listed, Brazilian institutions as Congress and the Supreme Court have been suffering numerous attacks and threats constantly in the past 4 years. Once our institutions' will is to always protect democracy and its fair play, what do you think that we missed on to legislate and discuss in the past? Did we leave loose ends that have to be tied up now? What has to be done? This is a first question. I don't know, esteemed colleague, would you like to respond question after question, or should I read out all the questions as you prefer?
Whatever you think is better. I don't know the number of questions you have.
It's 3 questions altogether. They're all relatively long, so maybe it is better if you would give an immediate response to the first, because you might.
You are the coordinator. I follow.
Good. I think that's preferable.
Okay. So let me first, I really appreciate your presentation, and I hope I had spoke last so we could have more time for the dialogue. But I would say that the 2 strategies that you are presenting as cautious strategies, I fully agree with them. Most of all, because we have a Supreme Court that at the same time left the previous period, as I said, with problems of legitimacy. So it is a strong institutional court, but with a political capital that has been devaluated in the last period of the Brazilian politics. So yes, the court should be very cautious. So this I fully agree. And I also like the idea that perhaps the most effective way of being cautious is to strengthen the capacity of other institutions, as it did on the case of the COVID, in strengthening the capacity, institutional capacity of the states and municipalities, and as it did on the investigations, the legislative investigations, providing robust defense of the capacity of the Senate to inquire into abusive practice by the government. So I think this is, I use the term in Portuguese, protagonismo compartilhado, which is share protagonist. That's what you have. You don't have to be the king of the game, but you have to find partners to protect democracy. One observation so I agree fully with everything you said. One point is when a key institution, which is the Attorney General's office, does not function as well as it should. And then is the dilemma that was posed to the Brazilian Supreme Court after being attacked in such malicious way by several sectors of the far right. So if the Attorney General's office doesn't move, how do you deal with this? Obviously that none of us would accept, if we take the rule of law seriously, that the Supreme Court just do whatever it wants to protect itself. However, if there is on its regimento, its bylaws, its internal regulation, old clause saying that when a crime offends the court inside of the premises of the tribunal, the court can by itself start an investigation. Well, if a crime is committed in the internet, it happens in the premises of the court. Well, this is well, if the court and really here is where I think the Supreme Court got close to the idea of militant democracy that was invented in your country. So if you think the threat is real, if you think there are groups that are trying to invade the court, if you have all the intelligence providing this, and the article I didn't mention here, the military, who has a tradition of closing the court in Brazil, it's giving signals that doesn't like what the court is doing. So this is, I think, I will not answer to you, I will not disagree with you. I'm saying there are peculiar situations and where we are living on the limits. And I think the case you mentioned is one of these cases where the Supreme Court had to take a decision in the limits. It's interesting that the investigation is not getting to an end, but the investigation is being very effective to slow down the pace of the right wing. So it's interesting because this you create a kind of a tug of war. Okay, I'm doing an investigation. You don't say my investigation is legit. The court is moving slow, but the investigation keeps being there. Well, it's just a footnote to your wise commentaries. Regarding the answer, yes, I don't think the role of the court is to reform the system. I think the role of the court in a moment like this is to resist, is to try to gain time so the political system resolves to itself. And this gaining time will have a window of opportunity in October. We will have elections, and hopefully those who are a threat to democracy will lose. They will keep on the political system, so they will keep being a threat. They will have a very good function of saying unfulfilled promises of democracy cost much. So if the democracy is not as efficient as it proposed itself to be, it will pay in the end. So I will not provide answer on the merits. But I think the role of the court this moment is to protect the core of the democracy, is provide that we have a fair elections in in October of 2022, that the elected government takes post, and we move on, and then we think about the reforms. But there are several reforms. I think the core of the problem resides on the party system, on the representative system, that because the representative system eroded in certain way, that populism found the opportunity to grow. So I think most of the reforms should be oriented in one side to the party system, and the second to create a less unequal society, because in a very divided and unequal society, obviously populism is a card always to be presented.
Thank you very much for your extensive response to my comments, and also for the answer to the first question. And I think, dear colleague, you have prophetic vision, because you actually also answered already the second question without having heard it, which was about the way forward after possibly, hopefully meeting the challenge in October then maybe, and returning to more normal times. What would then the way be forward? I think you answered that already. And so we turn to the last question, which I think relates a little bit to a similar question that has been asked in the first panel, asked by Josiel Silva. The question is, what mechanisms or tools can the Supreme Court use to bring the Brazilian citizen closer to the courts in order to work on populism and strengthen ties with the people? How can these tools be employed?
Well, Brazil had an explosion of litigation in the last 30 years. So courts in Brazil are accessible and are accessible for several sectors. Brazil has a large agents of public defenders office in the states, in the union. You have the public prosecutorial office, which has a very wide jurisdiction, not just in criminal case, but also represents vulnerable people in several circumstances. I say, well, Brazil created the agencies to represent people in the judiciary. We have a structural problem and we have an institutional problem. The structural problem is that Brazil is extremely unequal. So even though we have large agencies of representation, large parts of the population do not understand in the sociological terms its condition as right holders. So there is a problem of inequality when it's persistent. And why? That for generations have been imposing a social role of a person as an under citizen. So this is one structural problem. And obviously that the Brazilian society is not statical. Obviously that the Black movement in Brazil has been extraordinarily energetic and requires a different role and position itself in a different role. Obviously that women did a velvet revolution in Brazil in terms of questioning violations of their rights. But I think there is a structural problem of the Brazilian society that is still extremely unequal, so people don't view as equal right holders. So this is one issue. Second, even though Brazil created these agencies of representation for the most vulnerable, the judiciary is captured by the frequent litigators. Okay, so if you take yes, we have a litigation revolution. The numbers increased immensely in 30 years. But who occupied the judiciary? You will see. First, the federal government. So the federal government used the judiciary as a tool, sometimes to retard its obligation, sometimes to claim from the citizens some positions. Then you have the banks. Banks are the private users of the judiciary to charge their bills, to do things with their consumers. And then you have all the new informational economy. So cable television, etc., who don't do their duties, and then people go to the judiciary and stay there. So obviously that there is a problem of incentives that were created for those who are not willing to fulfill their responsibilities to ask protection in the judiciary, including the governments. So the federal government is the largest litigator in Brazil. The state of São Paulo is the second largest, and the municipalities are the third. And then you come the banks, and then you come all these new massive consumer companies. So yes, Brazil has more than 100 million cases a year, but who are the litigators? Normally are one of these 10 top litigators that I mentioned. And why? Because they use the judiciary to protect their interests. So that's, I think, is a reform that we have to think in terms of procedural rules, etc., to disincentivize these frequent litigators.
Thank you very much for your comments, and thank you very much once more for your excellent presentation, dear colleague. And with that, I would now like to return to the Master of Ceremonies.
I just would like to thank you also for your very interesting presentation, arguments, and it's wonderful to establish this dialogue. And I would also like to thank you, those who invited me in the person of Livia Guimarães.
We come to the end of this inspiring webinar, a joint effort of the Brazilian Federal Supreme Court and the University of Münster. We thank the panelists and debaters for the rich debate, and we thank you all for your participation and audience. With due authorization, I declare this event finished. We wish you all a great weekend.